Hello, this is Brad Carmack, author of Homosexuality, A Straight BYU Student's Perspective. You're welcome to check out my book for free in soft copy by visiting my blog at bradcarmack.blogspot.com. You can also watch it in a series of YouTube vids by clicking a link there. If you'd like to purchase a hard copy, you're welcome to do so by emailing me at homosexualityperspective@yahoo.com. This is part 3 or 4 of rebuttals to the common arguments you hear that oppose same-sex marriage. Earlier we've talked about parenting and child consequences in part 1. Part 2 we talked about religious consequences, and here in part 3 we're going to talk about legal consequences. So I'm going to address 8 common contentions and give my rebuttals to each. Alright? So the first contention is that legalizing same-sex marriage would lead to marrying animals, having polygamous marriages have to be recognized, etc. So my contention there is that it's impossible to say what expansion will happen in what marriage looks like based on legalizing same-sex marriage. But it seems unlikely that any restrictions that apply to same-sex marriage and opposite-sex marriage wouldn't be whole and complete inside themselves. Meaning, like, let's say there's a limit to how old a person has to be. You have to be 18 at least to get married, or 16 or whatever. That same age limit could apply to opposite and same-sex couples. Maybe there's a limit on relatedness. You can't marry anybody that's a first cousin or closer to you in relatedness. Well, that same standard could apply to same-sex couples as well as opposite-sex couples. There's no necessary relationship between legalizing same-sex marriage and legalizing marrying a rock or your dog or marrying 3 people or anything. All of those expansions of marriage would have to succeed on their own merits. Same-sex marriage merely expands from a man-woman only construct to a man-woman or a man-man or a woman-woman. So it's a limited expansion rather than an unlimited expansion. To conclude, there's a quote. It says, "Gay people are not asking for the legal right to marry anybody they love or everybody they love. Instead, homosexuals are asking for what all heterosexuals possess already, the legal right to marry somebody they love." Okay, so that's the rebuttal to the same-sex marriage will lead to marrying animals and rocks and polygamy argument. The second argument is that the state has no interest in gay marriage. The idea is homosexuals can live together already. So what state interest would be served by permitting the marriage of same-sex couples? Well, there are a number, and we'll talk about some of them later, some of them being legal ones, meaning if in fact same-sex marriage is a right, the deprivation of that right would counter the state's interests in equally protecting all of its citizens. But looking more at a consequentialist view that's apart from legal ramifications, we can look at what are some of the effects of marriage and the likely effects of marriage on the homosexual population. Well, if you don't have recognition of marriage, then there's a disincentive economically and socially for homosexual unions to have lifelong commitments. It's the same way that you see differences between cohabiting opposite-sex couples and married opposite-sex couples. There are distinct benefits that are known to be significantly correlated to marriage versus cohabitation. An example of this would be the willingness of relatives to help a family financially when they run on hard times. It's been shown that families are more willing to do so when the couple is married versus when they're cohabitating. There's also another example would be the better asset allocation that happens. So let's say that people break up, they've been living together for a decade. It can be fairly rancorous whether they're married or cohabiting, but if they are married, there's a whole set of rules that apply to how you equitably allocate the assets in that relationship. So when there's divorce or separation, we see distinct benefits for those that are married compared to cohabiting couples. And of course, we could name more benefits that are likely to accrue both to same-sex couples and to society by having marriage available for them. So there would be, the counter there is that the state does, in a number of ways, have an interest in same-sex marriage. Also, we'll move on now to the third of 8 contentions against same-sex marriage based on legal consequences. This one says that the recognition of marriage is not a universal right. Okay, so one quote from a person making this argument is, "The debate over whether the state ought to recognize gay marriages has thus far focused on the issue as one of civil rights. Such a treatment is erroneous because state recognition of marriage is not a universal right." That point is very hotly contested. The United Nations Declaration of Human Rights, Article 16, says the following: "Men and women of full age without any limitation due to race, nationality, or religion have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution. Subsection 2, marriage shall be entered into only with the free and full consent of the intending spouses. And third, the family is a natural and fundamental group unit of society, is entitled to protection by society and the state. So there's a contention there on both from the textual basis of the UN Declaration on Human Rights. Also, a right to marry has been recognized as a federal constitutional right in the United States in a number of Supreme Court cases. You can see a list of these in the Perry case. So the contention here is simply a kind of a factual one, that indeed state recognition of marriage is a universal right, arguably, and at least is such, and has been recognized as such by the United States Supreme Court in the United States. Okay, so that's the third argument against same-sex marriage. The fourth argument is that individual states, rather than the federal government, should be allowed to define marriage, and this is an especially important argument. The basic idea is that marriage and family law is a states' rights issue, and that the federal government has no business and no jurisdiction constitutionally to define marriage or to intervene or impose its will or judgments in the area of family or marriage law. And that states have the right to define the nature of the marital relationship within the state, and that the definition of marriage can vary from state to state because it's a state's right. The contention here is that the right to marry has been recognized as a federal constitutional right. This is vital. You're not going to find it in the text of the Constitution. Like many unwritten fundamental rights, it's been recognized as existing in the Constitution, though it's not explicitly written. By way of comparison, we could ask, what would happen to the right to bear arms if every state was allowed to legislate on what that means in their state without any limit? What would keep a state, like let's say Wyoming, from completely legislating the right to bear arms away? Or maybe saying that the right to bear arms is limited to the privilege of carrying around a penknife, but you're not allowed to own firearms. I mean, the right to bear arms has got to mean something, and if you're going to allow the state's unbridled discretion in how to define what the right to bear arms means and is defined and looks like, then you're going to have United States citizens that are deprived of the United States constitutional rights as soon as they enter that state. Now, it's fine for a state to give greater or irrelevant rights. They could give them a right to ride a bicycle. It's probably not found in the Constitution. A state could give that right. They could give you a greater right to bear arms than the United States Constitution does, but they absolutely may not give by statute, by conduct, or by constitutional amendment or provision less of a right in a certain area, such as the right to bear arms. So the reason this is relevant is if, in fact, the right to marry is a federal constitutional right, which has been noted in over 10 United States Supreme Court opinions, then the United States Supreme Court must give some sort of a definitional floor. So the states have discretion above that floor, but they don't have discretion to go below that floor, else they would be depriving United States citizens of their rights under the United States Constitution. So that's the rebuttal to the states having the discretion to define marriage however they please. So if indeed the federal judiciary decides, as for instance Judge Walker did in the Perry case, that the right to marriage includes the right for same-sex couples to marry, then no state can nor should be allowed to offer a definition of marriage which is less than the definition offered by the federal judiciary. That argument about individual state rights flows well into the next contention, which is that the federal judiciary violated the sovereignty of the people when it overturned Proposition 8. A lot of people, including the response by the church, were disappointed with the Perry opinion in that it seemed to overcome the consensus and vote of the California people in saying that Proposition 8 was passed such that same-sex marriage would not be recognized in the state of California. It looks like tyranny to have the right of the will of the people as expressed by the consensus vote overturned in this way. To rebut this claim, we're going to go to a little bit of constitutional law and a little bit of philosophy of law and social contract, right? So in 1787, we the people came together and gave up a portion of their power to form the Constitution. So they came together, hypothetically, theoretically, they had all of their sovereignty. Let's give that a value. We'll say each of them brought all of their sovereignty, which amounted to $100 each, okay? So they each gave 5 of their sovereignty dollars up to form the Constitution and this limited government. So they said, we're going to give away this small percentage of our sovereignty in exchange for the security of the Constitution, providing for the domestic tranquility and assuring blessings of liberty to ourselves and our posterity. We're going to pay for that with these 5 sovereignty dollars. Well, at the end of building the Constitution, they've only got 95 sovereignty dollars left. And so when there's that's part of that sovereignty or that constitutional right is exercised by the government and it infringes upon the liberty of the people, we can't say that that is unjust or a violation of sovereignty because we contracted that sovereignty away. I think a lot of the angst by people on a lot of government action comes from this illusion that we still have 100 of our sovereignty dollars. It's considered theoretically that we the people gave up some of that in order to form this limited government. We're no longer fully sovereign like a people would be in a state of nature. Okay, so this is an important contention about the federal judiciary violating the sovereignty. Now, one could definitely argue that Judge Walker got it wrong, that the Constitution does not give this right to same-sex couples, and because it doesn't, that the issue is left to the discretion of the people, in which case it would definitely be inappropriate to overcome and overturn the will of the people as expressed in passing Proposition 8. However, if in fact, and again this is a difficult determination, but it has to be made for the Constitution to have meaning, that same-sex marriage isn't a constitutional right, or if it is a constitutional right, then that did not overcome the will of the people because they gave up the right to decide what constitutional rights look like when they made the Constitution. That's how the theory goes. So the difficult question, of course, is who interprets the Constitution. It's a difficult question. The way that we've answered it so far, from what I can tell, is to give that buck and have it stop at the federal judiciary. Now, certainly you could propose alternative or better forms of interpreting the Constitution, but you've got to have some sort of interpretation. If there's no judgment, the Constitution is meaningless, right? So the question is, if it's not the federal judiciary, who's going to make the call on saying what the scope of those $5 of sovereignty that we all gave up looks like? So the right to marry is established as a federal constitutional right. It's binding on the whole country. And the question is, even if, for instance, we could say that we the people didn't give the responsibility of judging constitutional issues to the federal judiciary, let's say that the right to marry isn't there, it seems that a right binding on the whole people should be decided by more than just the people of California. So it seems like a national consensus should be required to evidence the will of the people if there's going to be sort of law that's binding on the entire people. So certainly if there's a constitutional limit that same-sex marriage is not part of the Constitution, then the question is that definitely shouldn't be, well, I would assert that that's not going to be answered, that question of constitutionality, by the people of California. If it's not going to be the federal judiciary, it should be some other entity that has national representation. Congress is one option, the president's one option. The people of one state or the legislature of one state is not a very good one because it doesn't represent the consensus of the people. And indeed, there's not really much constitutional basis for having a state or the people of a state defining what a constitutional right is. So to conclude here, it's the job of the federal judiciary to decide the limits of the Constitution, and that's the reason why the fact that Judge Walker made the decision is not inappropriate constitutionally, although of course one can argue whether or not Judge Walker got it right. Okay, so we've done 1, 2, 3, 4, 5 of the 8 arguments here against same-sex marriage. Again, these are legal consequences based arguments, and I'm rebutting each one in turn. The next argument is that we can't trust the courts, that they perhaps are self-interested, and we don't like the way that they interpret things. For instance, we don't like the outcome in Roe v. Wade, the famous abortion case. And that, that's an important contention. But the question is, if we can't trust the courts, who can we trust to decide the scope of the application of constitutional rights? And that's the argument that was posed immediately before. If it's not the federal judiciary, who is it? The Constitution is meaningless without some sort of judgment. And if we prefer democracy to make these judgment calls, put these kind of questions to a vote, we've got a lot of perverse results that most of us wouldn't like. Let's say that Alabama, for instance, decided to strip all LDS temple attenders of their driver's licenses. And that's what the voice of the people decided. Most of us wouldn't, in America wouldn't be very happy about that. And we would prefer a quick remedy to overturn that statute by the people of Alabama. And that's part of what the Constitution is. There are fundamental rights there that are protected across the country, and aren't subject to being repealed or limited by the will of the people of an individual state. The quote here is that the majority of California voters supported Proposition 8 is irrelevant, as fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. There are certain issues that we relegate to the federal judiciary to decide. Those are constitutional rights issues, and they're not subject to democratic vote. If they were, there's a lot of perverse results that I think most of the audience here would agree with me are ones that we would prefer to avoid. Okay, so the next one, this is the, I think the 7th out of the 8 arguments we're going to look at. The argument is that same-sex marriage is a violation of gender equality. This quote, I believe, comes from a famous LDS feminist scholar named Valerie Hudson. It says that no gender unequal relationship, even if it is called marriage, and no gender apartheid relationship with a person of the same sex or with no person at all, can ground the households of the family, human family, in gender equality. So the idea is this gender apartheid. If we've got same-sex couples that are married, it doesn't force them to come together with the opposite gender. And if you want gender equality, you've got to have men and women who are bound together in marriage. Well, the response here is it's a comparison to interracial marriage. There used to be a ban, for instance, that a black man and a white woman couldn't get married. That was illegal. That was overturned as a violation of the United States Constitution, as we know in a famous case. So the question here is, if you have to have racial equality, would we require that an African American have to marry a Caucasian? Or that a Japanese person has to marry a non-Japanese person? Or that a Filipino has to marry someone from Mexico? Should we mandate that people of different religions have to get married? That Catholics and Jews should marry each other? Should we forbid the marriage of two Southern Baptists in order to promote religious equality? The quote here is, one must wonder why it is necessary to prohibit same-sex marriage to promote gender equality when it suffices to permit interracial marriage to promote racial equality. It does seem strange that to promote racial equality, you would want to legalize people of different races to marry, whereas you would want to have enforce two different genders to marry in order to promote gender equality. It doesn't seem to flow logically. And also, I would argue that apartheid is not an appropriate comparison. Same-sex marriage doesn't mandate that all people have to marry those of the same gender. It creates an option. No doubt most people will continue to choose to marry someone of the opposite sex, especially given the strong cultural trend in that direction and the large incidence of heterosexuality in the population. To end the quote here, the offensiveness of miscegenation laws is not merely because it privileges one race above another, but that race is simply not an appropriate basis for limiting or granting the privilege of marriage. Gender is inappropriate by the same token. Last on this argument, those that extol a traditional or man-woman construction of marriage, there's been a large period of history, I guess I'll quote it here, by extolling a period in our history during which women were not viewed as equals, and by refusing to permit the needs of same-sex couples and their families to be met, same-sex marriage opponents may be doing more harm to the institution than they allegedly venerate than the recognition of same-sex marriage ever could. Okay, so certainly the old form of marriage in which women were the less equal of the two partners is not an institution to which most of us would prefer to return, even if we favor on its face traditional marriage. Okay, so this is the last, the 8th of the 8 arguments that have to do with legal consequences that oppose same-sex marriage. This one is that opposing same-sex marriage is not about sexual orientation discrimination. It's about gender discrimination. And we just talked about gender discrimination on its own merits. And I would concede that the two are different. Sexual orientation discrimination and gender discrimination are different. However, the sexual orientation discussion is related because gender discrimination in marriage has a disparate impact on gay and lesbian people. So let's take an example from a related field, employment law. Let's say that the Tucson Police Department refused to hire those who knew Spanish and who had lived more than a year in Mexico. On its face, this is not race and it's not national origin discrimination, but the policy would have a disparate impact on Mexican immigrants compared to other applicants. And because of this, it would violate federal discrimination law. This is the disparate impact test. So you're not explicitly discriminating against Mexicans, but you find a trait that they have more often than others, and then you discriminate on that basis. It amounts to the same violation. Similarly, because gay and lesbian people are overwhelmingly represented in the population of those who seek same-sex marriage, gender discrimination disparately impacts that group of people based on their sexual orientation. So a ban on same-sex marriage does amount to discrimination or burden on a particular sexual orientation because the population seeking same-sex marriage is overwhelmingly homosexually oriented compared to heterosexually oriented. The way that this came out in the Perry case, this is a quote from, I believe, the language of the Walker opinion. Sexual orientation discrimination can take the form of sex discrimination. Here, for example, Perry is prohibited from marrying Steyer, a woman, because Perry is a woman. If Perry were a man, Proposition 8 would not prohibit the marriage. Thus, Proposition 8 operates to restrict Perry's choice of marital partner because of her sex. But Proposition 8 also operates to restrict Perry's choice of marital partner because of her sexual orientation. Her desire to marry another woman arises only because she is a lesbian. Okay? So gender discrimination and sexual orientation are related in that way. And arguably, marriage has elements that are not limited nor completely encapsulated by its opposite genderness. Again, from the Perry opinion. Marriage has retained certain characteristics throughout the history of the United States. Marriage requires two parties to give their free consent to form a relationship, which then forms the foundation of a household. The spouses must consent to support each other in any dependence. The state regulates marriage because marriage creates stable households, which in turn form the basis of a stable, governable populace. The state respects individuals' choice to build a family with another and protects the relationship because it is so central a part of an individual's life. A court in Alaska made a similar argument, but says that the right to choose one's life partner, rather than the right to marry another of the same sex, is the relevant question. It said the following: government intrusion into the choice of a life partner encroaches on the intimate personal decisions of the individual. That relevant question is not whether same-sex marriage is so rooted in our traditions that it is a fundamental right, but whether the freedom to choose one's own life partner is so rooted in our traditions. And I think that I believe the Alaska court found that that right was fundamental. You could also approach this question from a right to dignity perspective. Here's a quote. It says, given that the state already recognizes a right to marry for opposite-sex couples, if this is not a sufficient basis to extend that right to same-sex couples, I do not know what would be. It is then almost a self-evident truth that same-sex couples ought to be afforded the same legal right to marry in the name of human dignity that is afforded to opposite-sex couples. So there's a route from the right to same-sex marriage, the right to choose one's life partner, and the right to dignity are all bases for arguing that that access is protected. To close, again, this is the argument about same-sex marriage prohibiting being about gender discrimination rather than sexual orientation. It says, because a person's sexual orientation is so integral an aspect of one's identity, it is not appropriate to require a person to repudiate or change his or her sexual orientation in order to avoid discriminatory treatment. And that came from the marriage cases opinion out of California. This concludes the rebuttals to 8 separate arguments that you commonly hear in opposition to same-sex marriage that are focused on legal consequences.